reading. So it's United States Court of Appeals for the Ninth Circuit. Jose De Castro v. LMPD et al. Appellant's informal opening brief. And I'd like to thank very much the person who sent this to me. I'm not sure if they want to be named. If they're watching, and they can send me a message on Discord, and I'll name them at the end. But I do thank you for sending it to me. Right. Jurisdiction. This information helps the court determine if it can review your case. And as I say, this is the first time I'm looking through it. So, filed notice of appeal, August the 14th. Let's have a look at the facts. It's not worth reading anything before there. Right, I'm a member of the press in Las Vegas, Nevada on March 15, 2023. I was recording a police interaction between Las Vegas Metropolitan Police Officer Brandon Bork and a citizen. I was in a private parking lot open to the public where I was authorised to be. Although I made no overt action to interfere with any investigation happening, and I was standing in a place where Bork could easily keep an eye on me for safety reasons, Bork asked me to step back, which I did, significantly. Bork demanded that the person he investigated deserve privacy and demanded that I step back even further, contrary even to the Las Vegas Police Protective Association's training. Citation needed. Although my rights were clearly established by binding case law to record police and to record in public, Bork tried to enforce his unlawful feelings instead of law. When I asserted my rights as a member of the press and further verbalised my criticism in exercise of my First Amendment right of speech, which is also a clearly established right backed by binding case law, Bork charged toward me and... Sorry. I can't laugh because I've got to go out. Bork charged towards me intent to unnecessarily manhandle me, and he did unnecessarily manhandle me. Bork called for backup, and with the support of his supervisors, I suffered excessive force and battery from Bork and his fellow officers, which has left me with lasting nerve damage. Citation needed. I was subjected to subsequent unlawful arrests, unlawful search and seizure, and unlawful abuse of process. Bork and his supervisor on scene even violated their agency misdemeanor arrest policy to book me in retaliation for the exercise of my rights and my viewpoints. While a similarly situated individual should not have been arrested by police, let alone practice. I was up to there, wasn't I? One of the officers that was on the scene has continued to harass me and my dog after the incident. Although there was no probable cause to arrest me, I was arrested and charged with 2 misdemeanor crimes, although no facts align with the required elements of the crimes. I've essentially been charged with contempt of cop. Don't think there's such a charge, Chile. Which is obstruction and resisting. No, it's called obstruction and resisting, not contempt of cop, Chile. At no time did I legitimately obstruct any investigation, nor did I resist any actions in furtherance of my arrest. Further, there was no intent. The criminal charges are meant simply to harass and chill my civil rights and are interpreting state statutes in a way that violates my civil rights and is contrary to prior binding case law. Since then, the judge handling the criminal case has stated that I need to lower my expectations on what discovery I will get from the state due to it only being a misdemeanor case, contrary to law and clearly indicative of my inability to get a fair trial. I feel that my criticism of police misconduct will end up getting me killed should the malicious prosecution continue in such an illegal manner. Proceedings before the District Court or the BAP. In this section we also... what did you ask the District Court or the BAP to do? Okay. I asked the court to stay the criminal proceedings which were brought maliciously against me for the only purpose to chill my rights, and where the malicious prosecution would harm me and I had a reasonable fear of additional excessive force based on the record. The court denied the injunction, although it had not been opposed. The reasons the court provided were: 1, I did not say what the first criminal hearing was about, which was irrelevant and which I didn't know, and the court could have had an evidentiary hearing. 2, the court incorrectly applied a younger abstention. 3, the court was ignorant on how a misdemeanour charge with a penalty of jail could result in jail. I don't know which court that is, Chile. My motion to reconsider with video of the incident was denied because it does not offer sufficient reasons to change my mind, although it raised the errors in law and fact. In your head only, Chile. Right, these are the claims. My complaint raised claims of 4th, 14th, First Amendment civil rights violations, battery, unequal protection, assault, false arrest and imprisonment, invasion of privacy, negligence, and Manel claims of policy, practice, supervisor liability and failure to train. My preliminary injunction raised Dombrowski v. Feister. Citation. So, yes, he is correct. He isn't a prisoner. He's a lot of other things, but not a prisoner. We ask you about the issues related to the case. What issues are you asking the court to review in this case? Right. Should a court refuse an injunction to stay a criminal proceeding brought illegally and in bad faith to chill a person's rights and to harm that person in retaliation for exercising their rights? Does younger apply where civil rights are involved and the person hasn't been charged? Should the court sua sponte assume and infer facts in support of the opposition of a preliminary injunction, even when those facts are contrary to the declaration by the movement and no opposition or proof has been raised by the other party, especially where the preliminary injunction would stop irreparable harm to a plaintiff and his civil rights? When video is offered as proof of likelihood of winning on the merits, or losing on the merits, Chile, does the judge need convincing or only a reasonable jury? Should a court fail to follow its local rules for an emergency reconsideration and wait 2 months for a ruling, even when all procedures are followed by the movement? These questions must be answered in the interest of justice. Did you present all the issues? So no. If not, why not? I raised all except for I did not have the opportunity to raise the delay of the emergency motion or the factual analysis of the video, which should have been determined on whether a reasonable jury could find for the plaintiff, not on whether a judge is convinced, which I now raise as trial court error on appeal. Good luck with that. Right, we've got a lot of statutes supporting the appeal. So I just read what he's, am I going to read these out? No, I'll just scroll them through for you. You can pause, go back later and look at these. Do you have any other cases pending in the Court of Appeals? Well, no. Previous cases. Jose de Castro. Hang on. He's probably going to strike me for that. 9th of the 9th, 2023. I'm not going to go down because there might be a phone number in there, which you definitely will strike me for. So, thanks for joining me